Because what Jenkins was about, as I said, it was pre-McCanty, was the very similar analogous situation in terms of a trust instrument. But under this trust instrument, the succession of the principal was actually already mandated into the trust instrument. So it was set out in line of verse what was to happen. And basically, it provided that on the death of the current principal, the legal personal representative of theirs would automatically step in and take over control of the trust. Now, again, this particular individual went and got legal advice, decided that that wasn't what he really wanted to have happen, and he wanted a third party to come in and be the principal / appointer of that family trust. And so he went ahead and did a deed of variation in his role as the controller of the trustee, but he failed to get the consent of the legal personal representative in doing that variation, and failed to get the consent, I should say, of the appointer / principal as well. So it all basically happened in the background. No one found out about it until after the date of death, and the legal personal representative, who was the one that was going to actually take control if the original deed stood, challenged it and said, well, hang on, the variation power that was purported to be exercised here only referred to the trust deed itself, and yet the variation was made to the schedule. And because the definition of trust deed does not refer to the schedule, then you can't amend the schedule. So that was probably simplifying it a little bit, but basically they said the variation power only applied to the deed, the schedule is not included in the deed, and therefore any purported variation of the schedule is invalid. And the court said correct. The court said the purported variation was outside the terms of the variation power. It was an invalid variation. The original trust instrument stands.